Good evening. This is actually a video explanation designed for my clients. So hello to all my clients. To let you know that your application was filed and what you need to do next and what will be happening next, to give you the strongest chance of getting a very strong case and prevailing as early as possible. Okay, but I'm sharing it to everybody because those of you, you may or may not have a representative. Your representative may or may not do things the way I do. But some of the things I say might help you if you don't have a representative. And obviously, when it comes to sending things to me, that would not be something you'd be doing. But other things to look out for will be in here. So you might get some use out of it. So I'm going to make it public for everybody, as opposed to the one I privately have been sharing to my own clients. Okay, so application is filed. For my clients, your biggest thing to look out for next, oftentimes, will be a letter from the SSA with a printout, and this is particularly for Title II. Let's just talk about Title II. That's Social Security Disability for now. Title II, they will give you a printout generally if you applied online of what your answers were. Sometimes there seems to be a couple things thrown in there that might have not have been in there, but in any event, they're going to ask you to review it. If anything is incorrect, make the changes and initial them. And then there's a back page that they want you to sign off on the whole thing as you've amended it, but you initial each change you made. They're going to want you to send that back. They often provide an envelope and an insert with the address, so you can do that. Don't forget to keep a copy for yourself, okay? If you're my client, I want you to send a copy to me too. That would mean uploading it to the portal I share with you with your account, or you can get it to me any of the other ways that we share things. Fax, that kind of thing. You can mail it. I always say if you're going to mail something of importance, UPS or FedEx. But if you're mailing it to the SSA, there is always the option of certified return receipt. I would never mail something like that to the SSA. That they're getting it is what your case depends on for being processed. So when you get it and you make your copy, and if you have a rep like me, you're going to send it to your rep like me, unless your rep doesn't want you to, confer with them and send it to, in my opinion, the SSA certified return receipt. So you get that little green card back. Keep a copy of the fact that you sent it. That's going to be on a receipt from the post office. And also, when you get the green card back, you're going to want to keep a copy of that. And again, copies of that, if you're my client, comes to me. So just take a picture, shoot up the text, all that good stuff. Preferably to the 805 portal number, not necessarily my 201 business cell phone number. But either way. And then the next step after that when they get that is when they now there might be some intervening issues they want to confer with you about, like if you have a workers' comp case, or you reported that you're still working and they're not sure if it's SGA or not, and they might want to send out any additional informational requests or speak to you. If you are my client, I really don't want you speaking to them. So generally what I suggest is letting it go to voicemail. You get their name and their number, then you can give it to me and I will make the phone call. If there is a reason why they need to speak with you directly, and the only real reason I can think of at this juncture would be if you have an SSI application, they do tend to want to delve into a little more of your current finances to be sure that you are likely going to meet the non-medical criteria. They want to find that out before they send your case up to the regular workup at the state level, for all the medical evidence gathering and reviewing and analyzing. Because why spend the money and the time doing that if you're never going to be able to be eligible for SSI based on your finances anyway? But as most of us have Title II SSD claims, even if we do have SSI claims, some of us, that would not, to me, I don't want my clients speaking directly to the SSA. That's why they retained me, to reduce that stress load and to make sure they don't get befuddled. Not to mention, most of my clients are really stressed, and that is not good for their health, and they have disability problems. So in order to protect their health, I think whenever possible, it should be me doing all the communicating and not you. And I hope that's a relief to you. Just get that name and number and you give it to me and I will be, woohoo. Okay, so for the rest of you, if you don't have a representative, or your representative says, no, I want you to handle all your own communications, which I don't really understand, but okay. Then you would be wanting to promptly respond to them with whatever they've asked for. If you don't, it could end up in a case closure without anything ever getting worked up, case canceled. So you want to stay on top of all that. But if there is no such issues that they have to delve through, which I'd say the majority of cases, there is not all that additional. In your case, the application is in, everything's kosher, it's going to get sent up to the state level. Oftentimes you'll get a letter saying, we have received your application. And that could be that printout letter I was just talking about. If you have a representative, you should be getting a letter saying, we have received confirmation that you're being represented by Stephanie Joy or whoever the person may be. And they're just kind of letting you know that they have that information. If you're my client and you get that, please let me know you got that. And I'm going to say right here, and this is probably, I want to speak on behalf of everybody with a representative, but I don't dare. Anytime you get correspondence or a phone call, and like I said, let it go to voicemail if you have a representative like me. Anytime you get correspondence, you let me know immediately. Okay. And for those of you with different reps, however they want you to do it, I would default to always letting them know if they haven't said anything. Because sometimes you'll say, well, it's CC'd to Representative Joy, but sometimes we don't get it. And I don't know whether it's because it never makes out of the mailroom at the SSA, or U.S. Postal Service may not have gotten it to me because they don't send things FedEx or UPS or with any kind of protection. It's all regular mail. And we have issues these days with regular mail. So that is how you make sure that anything is seen by your attorney or your non-attorney rep, and you've done your part in your case. Okay, so unlike several years ago, now once it gets moved, when everything is in with the local field office, that's where everything starts. Once that has been all copacetic and everything's in as it needs to, and your signature is back and you have proof that you sent it and they now know that you did and all that good stuff, they're going to send it off to your state level agency. So basically it's a department in your state. Maybe they handle health and human services in your state, or it could be, I think I've seen one state, it was the education department, but they have this little section in there. It can go by different names, but it might be disability determination services. That's out by me, but I've also seen Bureau of Disability Determination. So it can be any of those names. You will see that there is it might say, like if you're a Pennsylvania Department of, and it'll refer to the state, but you have to look closely because it's probably going to be an SSA matter. If you have other things going on with the state, it could be something else, but it wouldn't say Social Security Administration then. When in doubt with me, and you're not sure if it's about some other state matter you have, maybe you're getting some sort of state welfare or something, food stamps, I don't know. If you're not sure, you can always take a pic and shoot it up to me. And I'll say, nope, that has nothing to do with what we're doing. Important for you and the rest of your life, but not part of what we are doing together in the SSA. Okay, so as soon as it gets up there, you may get a letter from the either a no-named office letter, or it'll be a letter with the name of the adjudicator who is working up your file. And usually there's a phone number and a fax to that person. And they're letting you know that they're going to be working on your case. And here's what you should do if you receive anything. If you are my client or the client of a representative like myself, when they say, send us blah, 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 you don't send anything to them. It all comes here. So if you have anything on that letter, and you're like, Stephanie, I got this letter and I don't know if you got it, but you know, blah, blah, blah. Always go through the representative if the representative is like me, and we do everything. Nothing should go around us, because then we can't keep track of what's going on, if something's going sideways, all that kind of stuff. You might get that letter first, you might not get that letter, but you will probably get a request, demand, whatever you want to call it, for something called a function report. The function report is about your activities of daily living and how you function, and you know, certain symptoms and whatnot. So when you get that letter, it's probably going to say it's due in 10 days from the date of the letter. And you'll probably have gotten it on like day 9, 10, or 11. And now you're in a panic. Well, if you're my client, you shouldn't be panicking, because as you recall, we already gathered the information for this report and other reports in our intake. Remember all that paperwork you filled out for me, but you got to do it a little more leisurely. So we have that data. And what we like to do is do the typing up of the report for you based on your data. And then you and I might have a little Zoom or a little phone conversation, because some things might look inaccurate, or you didn't answer it, or it seems like you misunderstood the questions. And we'll go through it, and I'll make sure you know what the questions are, so you can provide a more comprehensive response. And I'll make sure that that gets in. We will transcribe that for you. And then, because now you've let us know that you got the demand for the function report, we already have your answers all in this lovely report that's completely legible. And because the function report that you got has a barcode page, we will either be sending it up with the barcode page that you can just take a clear shot of and send to me, or we've also gotten a copy. If the DDS is doing it right, we should be getting a copy of everything you get, and we will have the barcode page then, and we will shoot it up. And that report will be in their hands probably the same day, if not within a couple of days. The same can be true for a possible demand for a work history report. Again, if you're my client, we've already gathered that information from you, and we typed it out for you as per whatever you put. Now, with the work history report, we probably will want to have a conversation, because by and large, people leave a lot of things blank, and we want it to be really clear and really accurate for the DDS, because your work history is a very, very critical part of their decision-making capacity for many cases, some more important than others. So it's really, really, really important that we go over that together as well. Once in a very blue moon, I could see the answers are fully responsive and in line with what the job was and stuff like that. But more often than not, no. So we probably will have a conversation, because we're not sending a report in unless it's accurate and responsive from you. So, you know, that's our job, is to make sure you understand the questions and are well able to answer them. Okay. And then again, we send it in, not you. So when you get this demand, don't get all paranoid and freaky deaky and start filling out in the middle of the night and then faxing it up to the, you know, the DDS fax number that you see. You really want it to go through your attorney, because there is a lot of things you're probably going to misunderstand. And I will also remind you that when you received our intake packets, and this is for my clients only right now, folks, because when I do my intake, I don't just sign them on and then let it go out the door. I actually gather all the information. This is from 20 years of practice and learning what works best, in my opinion, and for this particular practice. And every other rep has their own way of doing things, but I gather all the material before, if I'm the one filing the application, I've gathered a lot of information, such as for these reports that come after the application has been filed that we're talking about. I had that data from the client, and back when I had their application data packets that I asked of them, so I could properly draft up their application. And when I did so, I compared different things of these different reports. I compared the data that would be, in theory, going only to the, you know, function report later, or the work history report. But because I have the data so early, I make sure that it is driving what they say on their application materials, because sometimes you'll see differences. There'll be missing jobs. There will be some impairments that are not mentioned in the application, but then are going to be mentioned apparently, you know, in little narrative quibbles on a function report. Once I see that that's noted in a function report data that I've already gathered, I now we'll be adding it to the application before the application goes out. So the SSI is apprised of the existence of that claimed impairment from the get-go and not 3 months later or whenever. Okay, so you'll be getting that demand for the function report and the work history report. We have playlists on both of those reports. So whether you are my client or not, you can listen to, watch some of these videos on the function report. I have them broken out, question number 5, if you need help, question number 7. Because a lot of them, you're going to get a misunderstanding of what that question entails. Okay, so things are not always as what you interpret them based on your perspective of not knowing what the rules are with Social Security, eligibility and such. So, once you get that demand and it goes out, then you're kind of done with that for a while. There might be another report that they send out, though, called a third-party function report, and that is the SSA 3380. And they're asking basically someone who knows you personally well, so not you, but it could be a spouse, friend, family member, someone who kind of sees you a bit and knows what's going on. And some of the questions are probably not going to know the information to, but some of them they may. And they want, ideally, you to have someone that can fill that out and send it in. So if you're my client, have them, that would be something we already got from you when we sent you our data packets. One of them is the actual official report, a copy of it for your person to fill out. And so when you send that all back to me, I can send that third-party function report up to the SSA, and that person doesn't really have to do anything once that request comes in because they already filled it out, the actual report. If there was something that they just didn't understand and I happen to read it, I might ask them if they meant that, but we'll shoot that up for them also. Sometimes, now keep in mind, while you're doing all this, the SSA at the state level, the DDS or whichever name it's going to have, depending on your state, they are doing a lot of behind the scenes workup while you're doing all this. So you might not hear from them, but except for these demands for these reports, but they are ordering all those medical records that you put down in your application. And this is why it's very important, and we have videos on this, to be very thorough in your application materials. All right. Don't just throw a few doctors' names out, the ones you think are important. Not going to work. Anyway, so they're doing all that behind the work stuff. And your job, in my opinion, is to treat at this point for every impairment you have. While you're waiting for this process to go on, you need to keep that momentum going with your treatment, diagnostics. Your representative, if you have one that's like me, will have told you things that you haven't been treating for, but that you tell us you have a problem with, and you need to get those treated. And you might say, well, it's really not my big thing. My big thing is my back. I get that, but your back is probably not going to take you out of all jobs, not under SSA rules. So those little tiny impairments can carve out all those little peripheral, little remaining jobs, potentially. And that's what we aim for. So treating for all those things, being nagged to death by me is not unusual, to start, really growing those areas as well that you may have been blowing off because of your big bad problem. We have a video on that too. Of course we do. So treat. If your representative, says, oh, you really need to get updated diagnostics like MRIs, that's something you're going to want to stop pushing for. Get referrals from your doctors for all these things. If you don't have a specialist and you're dealing only with general practitioner, you're probably going to get nagged to get a specialist for that very special problem you have. It all goes to the weight of the evidence later. And the stronger you can make your case by following the directions without, questioning at every turn, because you're going to start getting quick and brief answers, the more you can do for your treatment, and you're the only person that can do it, the stronger your case is going to be, which means there is a better chance of you winning and winning earlier than there would otherwise be. So by not following the directions or, kind of putting your heels back and sitting back on your heels, you're adding to the weakening of what could be a stronger case. And I say that only because you are the one that has to live with the repercussions. I don't have to live with them. If your case doesn't prevail, it's you who's got the life-changing repercussions from that. I don't like it. but it's not me that has to live with the end results. Okay. So when I spend a lot of time, and I call myself the nag hag, nagging about, you should, in a perfect world, you're going to be doing this to make your case stronger. Da, da, da. It's not because I just like to babble and nag. It really isn't. I got very little spare time in my life. It's because it's something that I need to do for you, because it's my job to keep telling you things that you could do. If I see something in a medical record that says, "Ooh, maybe he should do this," I'm going to bring it up. Okay. So that's what you're going to hear from me going forward. For those of you who are my clients, if you have a representative who's like me, that's what you're going to probably be hearing from him or her also. If you don't, I can't speak to that. Different representatives and lawyers do things differently. I happen to be pretty involved with my people to the extent necessary, but hopefully not more than necessary. And that's how we roll. But the job after the application filing is treat. Okay. And if you don't have me for a lawyer and you have someone else and you get that function report and the work history report, you're going to want to bang that out. Again, I would go to those playlists on that. If your lawyer doesn't have a set or doesn't walk you through the work history or the function report, there's a lot of information out there, general, of course, in nature. And of course, I would think you would always ask your representative also, first and foremost, actually. Anyway, okay. So are we clear on what happens after the application? You're going to be treating. And if you're my client, anytime you get a new provider, you're going to provide me with one of those reusable forms that are up in your portal. If you don't see the reusable form in your portal under your documents, let me know. That means someone didn't put it up there, and we'll get it up to you right away. Every new office that you go to, okay, you're going to fill one of those out. If you've already provided one, or it was already in your application, just shoot up a message. It could even be the text message saying that, that you went to see Dr. Jones today, or I had an MRI today, and we will get that information where it needs to be and make sure that it's not left out. Because if you are self-representing, and this is for the self-representing people, or maybe some with attorneys or representatives that are not like myself, after you file your application, they order your records, and it could take months because they're very busy up there and short-staffed probably. And 3 months later, 4 months later, 5 months later, your case is still going on, and you've had all this other treatment, but you haven't told them about it. Maybe you had a couple of MRIs you hadn't had at the time you applied. You're going to want to let them know. So you have to deal directly with your adjudicator, of course, because you don't have a representative if you're representing, but you're going to want to let them know of certainly the big things, any diagnostics, any therapies. You start physical therapy, super important. Oh my God, I'm like obsessed with physical therapy. I've never had it myself. I haven't needed to yet, but I love the records for my clients. Any pain management things, injections, blah, 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 all that kind of stuff. You're going to want to pretty much in real time, like within a day or two, let your adjudicator know, whether you leave them a message or have a letter that you fax up to them. I don't know how you do it. But that's what you got to keep doing this whole time. And then you might be getting a letter saying they're going to send you to a consultative examination. That could be a mental or a physical, and you by and large have to go. So you want to make sure that happens. I have a couple of videos on what to look out for, how to, what to know about those exams, so you are well prepared. So feel free to look at those too. Consultative examinations, super important. A lot of times you're going to find them to be useless, but you don't want to make them more damaging than they would otherwise be. And sometimes they're actually helpful. You have a doctor or a provider that actually knows what they're talking about and can see what's going on in the exam. So, all right. And then usually after the C exam, we're probably close to getting this determination. All right. And that'll tell us whether we won at that point or we have to continue on an appeal. Okay. As you probably know, the majority of cases do have to continue on to appeal. All right. That's just the way it is. Perhaps in my practice, it's slightly less than others, only because we are very, very diligent early on. But if it is, it's certainly not a big enough difference to not expect that an appeal will happen. All right. All right. So that's it, guys. For my clients, we got that application in, it's done. Good job. And let's keep fighting. Okay. Let's do what we got to do. Keep your sleeves rolled up. Don't sit on your laurels, and treat. That is the biggest, most important thing for all of your impairments, big and small. All right, guys. Bye.